Hello everyone, I am Dr. Rohini, taking class for the MBA, first year MBA students, first semester. I am taking legal aspects of business. Among that aspect, I am taking the first unit with respect to basics of contract. So before going to this particular act, we have to learn first why that contract act is necessary and also why that legal aspect is deemed to be necessary. First and the foremost thing is, in every world, every person knowingly or unknowingly enter into an agreement of business. So in order to do a particular business, agreement between the parties are very much essential. So when agreements, any person violates any part of the agreement, then enforcement of law comes into play. For that reason, we have to learn how that law acts into the business field. So among that, we have to see whether that is, we have made it, that's the Indian Contract Act, basics of Indian Contract Act of 1872, but literally even in the Hindu law and in Muslim law also, that law of contract was well recognized. Even under the Hindu law, that aspect of this law taking the payment of the debt or consideration in case of gift, whether it is necessary or not, well recognized under the Hindu law. Even under the Muslim law also it was well recognized. But there was no uniformity in India with respect to contract. So in 1872, a common uniform contract act was said to be passed. So among this contract act, first and foremost, we have to see what is a contract and what is there in a contract. First thing is, we have to learn some of the definitions, especially according to H of the Contract Act. Contract means an agreement enforceable by law. Then what is an agreement? That very clearly says there must be a proposal and acceptance. Offer plus acceptance becomes an agreement. Suppose if that is so, then what is an acceptance? According to section 2A of the Contract Act, clearly says, when a person said to make a proposal, when he signifies his assent or his willingness to do or to abstain from doing anything with a view to abstain the other to enter into do that particular act or abstinence. That means if one person makes an offer or proposal to the another to enter into an agreement with him to do any act or not to do any act, that is nothing but a proposal. So the person who makes a proposal is called as a proposer or offerer or a promiser. Similarly, if one makes a proposal or an offer, another has to accept that. So what is that called as? Acceptance. So according to section 2B, what is said to be accepted means when a proposal to whom it is made, when he signifies his assent thereto, it becomes accepted. When any proposal is accepted, becomes a promise. Promise means giving a definite assent to do or not to do that act. So in offer there is one promise, and in acceptance there is a reciprocal promise. So according to section 2E, every promise, every set of promises forming consideration for each other is said to an agreement. So any agreement which is enforceable under the law is called under section 2H as agreement, is a contract. So in every contract there must be an agreement, but every agreement is not a contract. Say for example, if a contract of a social nature is not considered to be a contract because we cannot enforce. For example, if you invite any of your friends for a cup of tea and you make the preparation for an high tea, suppose if your friends didn't turn up, so you suffered a loss, then you cannot take any action against them because it is a contract of social nature. So in such cases, any agreement which can have a force of law or which can sue for the damages or anything from the other person to the aggrieved person, that is called as a contract. And accordingly, there is a foremost important of section 10 of the Contract Act. It clearly mentions what is a contract. So when according to section 10, all contract or all agreements or contracts when made by the free consent of the parties competent to contract and for a lawful consideration with a lawful object and not expressly hereby declared as void. That means this section 10 is, these are all the basics of contract. If you learn all these basics of contract, then we can clearly say that is contract act or agreement is said to be fulfilled. So it is very easy to learn contract act because contract act basically is an agreement between the parties to enter into a business, because we are talking about the legal aspect of business. So we are clearly mentioning in all the cases only with respect to business. So two persons or more persons entering into a contract of business. So if both the parties have performed their part of the contract, then the contract is said to be discharged. If one of the parties have failed to fulfill the contract, then what is the remedy for the other party? He must file for the damages or claim for damages. So among this contract act, what are the minimum or the necessary points are: one, there should be an agreement. Agreement means offer and acceptance all must be there. Then there must be consideration must also be there. Any agreement for a do a lawful object, and it is for a lawful consideration. And after the agreement is completed, the contract is said to be completed, then performance of the contract arises. After the performance, both the parties have discharged from their contract. If the contract is not said to be performed, and the aggrieved party can file against the other party for damages for not fulfilling the contract act. That's all with respect to contract act. Now we are going for the detailed explanation of the what is the basics of contract. This basic of contract act is called as a general law of contract, because there are special contracts such as contract of agency, contract of partnership, or sale of goods act, like that. So in every contract, this section 10 of the contract act must be fulfilled. Unless it is not fulfilled, the contract is said to be void. And hence, what are the types of contracts? So it is based on various methods. One is based on the method of formation. That is in the British rule, there is a contract records and under a seal. Contract of formal contract, there is a contract records means when under the order of a court, a contract is said to be performed. That is the contract of records. And extent of performance, how a person can perform his part of the contract. Among that, there are two contracts. One is executed contracts and second is executory. Executed contracts means if either of the parties promise made and the consideration passed subsequently for the past consideration, that is called as executed contracts. Executory contract means both promise and performances simultaneously done for the present agreement, that is called as executory contract. And thirdly, based on enforceability, that is the one and the foremost important. Among these, there are three contracts: void, valid, and voidable contract. Void, you all know, which act which cannot be enforceable. That means void from the very beginning, void ab initio. Say for example, if a contract entered with a minor, or if a contract entered with a person of unsound mind, or if a contract entered by fraud. In such cases, all contracts are void contracts. In case of void, there is no law can be exercised against any other person. And secondly, valid contract. If all the essential of section 10 has been applied or fulfilled or satisfied, then it becomes a valid contract. And thirdly, voidable. That it lies between the void and the valid contract. Suppose if any contract entered into under a mistake, under misrepresentation, under coercion, in such cases the aggrieved party can apply for the court to declare that it has a void contract. If it has not done so, then that contract becomes valid contract. So in case of a voidable contract, the party either must sue to declare or for the declaration to declare it as a void, or else that contract becomes valid contract. And depending upon the enforceability means because of some technical reason, a contract cannot be enforced. If such technicality has been removed, then it becomes a valid contract. And illegal contract, as you know, if any contract against the law is such illegal contract, that cannot be enforceable, that is also considered as a void. And based on obligation, that is if both the parties are ready to perform their part of the contract, that is unilateral. If one of the party is ready and other is not ready, that is called as bilateral contract. And we have to learn, before going to the other legal as section 10, we have to learn this offer and acceptance, because agreement is nothing but a combination of offer and acceptance. So when we can say an offer is validly made or when an offer is legally made. So what is essentials of a valid offer? Among that, first thing is the offer must be intended to create a legal obligation. I have already explained, if in any offer for to do a social obligation, it is not. Suppose if a promise to marry is not a legal obligation, it is a social obligation. In such cases, it cannot be enforced. So any offer which in order to create a legal obligation on the other person, that is a valid offer. Secondly, it must be certain and definite. Say for example, A asks B whether are you ready to buy my car for 3 lakhs rupees or 4 lakhs rupees. That means whether the car is being sold for 3 lakhs or 4 lakhs is not cleared. Hence, it is indefinite. So any offer must be very much clear and any vagueness must not be there in the making the offer, and it must be expressed or implied. In some cases, if a person simply hand over any goods to something, other person accept it, that is considered to be an implied offer, and expressed through the words of mouth or in a writing. If a person expresses willingness, say for example, if a person writes a letter regarding selling of the property to someone else, that is express offer, and it is distinguished from invitation to offer. There is always difference between offer and an invitation to offer. So what is an invitation to offer? Any menu card in a hotel, it is an invitation to offer. That means if you go for a hotel, the supplier will give you the menu. So based on the menu, you will order something. So while if you order for any of the things, that is made as an offer. So invitation offer is making the person to make an offer, that is invitation. So it is always different from real offer, and it must be either general or specific, that I will come later, and it must be communicated to the person to whom it is made. That means if I want to contract with B, I specifically mentioned the name of B or expressly made known to B that I am communicating him. Suppose if a person say for himself, so I want to sell my car, that is not a valid offer because it is not properly communicated. So communication is very important in case of an offer. And how a communication to be? A communication to be must in such a way that the other party or the opposite party must be understand what he is telling, and he must accept that or he must deny that. To do an act or abstain from doing an act, that must be there. And lastly, it must be, there cannot be a condition can be made in an offer, but non-fulfillment of a condition cannot be considered as a non-acceptance. He can put a condition, but the other party, the opposite party or the promisee may not accept for the, or he may not comply with the condition. That's also considered to be valid offer. And then among this, that it must be general or specific. In that we have that types of offer. One is a general offer. When a offer is made to a general public, say for example in case of a medicine, if a medicine has been found out, for example for a fever, dengue or anything else, that it will be made public, that whoever using this medicine, that will be a public offer. So when any offer is made to a general public, it is called as a general offer. Special offer means when an offer is made to a particular class of person or to a particular person. So A offers B, that I am selling you, I want to sell my car to you. That is specific offer. Then cross offer. Suppose if both the parties making an offer simultaneously unknowingly, in such cases it is called as a cross offer. In case of cross offer, it is not considered as a valid offer. Then counter offer. One person makes an offer. If the other party makes a condition or put a condition to that, say for example, A says, I am selling my horse to you for 10,000 rupees. But B says in turn, no, I am not ready if you pay you only 8,000 rupees. That is called as a counter offer. In case of counter offer, original offer lapses. Again he has to make a fresh offer. And lastly, standing offer. Standing offer means any offer which remains in force for a particular class of time. That is a standing offer. For example, that's a tender, announcement of tender. So you have seen in the newspapers, there are publications that to accept, whoever wants to accept this tender must write within this period. That is called as standing offer. Similarly, when an offer is made to a person, he must accept. So acceptance also must be in a particular way. So first thing is, acceptance must be absolute and unqualified. Suppose if a person makes a counter offer or he makes a counter acceptance, that is not a valid acceptance. That means when a person makes an offer, same way the acceptance must also be there, and it must be communicated. Who has made the proposal, the communication is also must be given to the or directed towards the proposer or the offerer and not to anybody else. And it must be made with a by the offeree or his authorized agent, because a contract of agency is a special contract act. So whatever done by the principal can also be done by the agent also. In such cases, it must be an offeree. That means an acceptance may be made by the offerer and acceptance by the offeree or his authorized agent, and must be prescribed mode. That means if the offerer makes the acceptance to be done in a particular mode, in the same mode acceptance must also be there. Suppose if the acceptor says you must write letter, then acceptance must also be in writing, or it must be by a telephone or maybe email, message or like that. So in the prescribed mode by the proposer, acceptance also must be in the similar mode, and it must be expressed in a usual manner. Sometimes expression not necessary in case of acceptance. Say for example, if any person in case of auction sale, if whoever accepts that auction must tender some earnest money. So tendering of earnest money itself is acceptance offer. So when there is a usage or the custom, that acceptance must be according to the usage and the custom, and it must be within a given reasonable time. So if the offer is for a particular time, then acceptance must be accepted within that time. Suppose if the time lapses, he cannot, even if the acceptance is made afterwards, it is not considered to be a valid acceptance. And also sometimes acceptance may be by conduct also. If the person retains any goods without expressly accepting that, that also considered to be offer acceptance by conduct. So when an offer and acceptance is made, so after offer is made or after acceptance is made, if the parties want to revoke their offer, how it can be made? So revocation offer, so when revocation of proposal or a revocation of offer, it can be made or it can be revoked before the communication of acceptance is complete as against the proposer. That means when the proposal is made, before the acceptor is accepted or before it put that his acceptance in the transmission, he must revoke it, not afterwards. Similarly, acceptance also. If the proposer accepts the acceptance, the acceptor cannot revoke it afterwards. So any acceptance must be revoked before it reaches the proposer. Then there are various ways of revoking the offer or the acceptance. One is by communication through notice. A party can issue notice to each other by revoking the offer or the acceptance. Secondly, by lapse of time. Say for in case of a standing offer or in case of a particular special offer, there should some time is prescribed. So acceptance is not accepted within that time, it automatically lapses. By failure of the acceptor to fulfill a condition. So I already told in every offer the condition can be made. So if the condition acceptor has not accepted the condition or had not fulfilled the condition, then it's said to be revoked. Or by death or the insanity of the offerer. If the offerer dies or acceptor dies, then because it is a personal contract, so offer and acceptance is said to be lapse. And foremost important is the consideration. So consideration means something in return. Means A must give something to B. In consideration, B must also give something to A. That is because anything done without any return, that is considered to be invalid. So in order to make a valid contract, both the parties have performed their part of the contract. One is promise and the plus performance. One person promises, other person performs. That is considered to be a consideration. So according to section D of the Contract Act, when at the desire of the promiser, the promisee or any other person done or abstain from doing or does or abstain from doing or act done or doing something, such act or abstinence or promise is said to be a consideration. That means if a person promisee at the desire of the promiser, say for example, A has lost his dog. So he requests B to find out his lost dog. In such case, that servant has written a particular dog. In such cases, the promise is made. That performance is made by the person and the promise is moved. So desire of the promiser, that the promiser means offerer. So offerer must ask for doing something. Say for example, A want to construct a house. So he asks B, a mason, to or request the mason to construct the house for A. In such cases, if B accepts, then at the desire of the promiser, the promisee is doing something. So in order to, at the desire, if the promiser makes a request to construct a house, that promiser must give something to the promisee. In such cases, the promisee may be any other person. So consideration may move from any other person, not necessary, but consideration at the desire of the promiser. First promiser, he must ask for something and the promisee must do something, but it can be done by any other person. And consideration may be past, present or future. Past consideration means if the act done and then consideration moves subsequently, that is past consideration. If both the parties have done their part of the contract simultaneously, that is a present consideration. If both the parties agree to do their act at a future date, that is called as future consideration. And consideration always must be real. Real means something to be sensible in the eye of law, but it need not be adequate. Adequate means it is not necessary that must be of equal value of the other consideration. Say for example, if a property worth of 10 lakhs rupees can be given or can be gifted away only for 10,000 rupees, because the value of the property is 10 lakhs rupees, but gift is made to only for 10,000 rupees. It is not adequate, but there's something consideration must be there, but it need not be adequate. But sometimes court will look whether that consideration is freely given or not. In such cases, adequacy will come in question. Otherwise, consideration must be real, not necessary that must be equal to the value of the property. And consideration must be immoral or opposed to public policy. That means Consideration must be with according to section 10, consideration for a lawful object and lawful consideration. So for example, any contract to do a gambling or to run a prostitute house, these are all the unlawful act. Such consideration are to A, give some money to B to murder someone, that is lawful consideration. So or if both the parties agreed to share the profit obtained from theft, these are all the unlawful consideration that is considered to be void. So I have already discussed this. Then adequacy of consideration. Normally I have already told, not necessary that the consideration and not of same value of that of the property or the thing exchanged, but in some cases consideration not necessary, where if a performance of what a person legally bound to perform, say for example if a public servant, say for example if a police officer, his work is to find out the thief or to find out the lost goods, in such cases consideration cannot be passed, not necessary to give consideration to the police officer to find out something, because law implies on him to do a lawful act. In such cases, if a person bound to perform some of the act, consideration is not necessary. But sometimes if the person does or he do more act than required, in such cases consideration can be passed from one person to another person. And consideration, any agreement without consideration is void, because I have already told consideration is very much essential according to section 2D. Consideration, no consideration is considered to be no contract, but that's what an agreement without consideration is void. But there are certain exceptions wherein if any consideration or any contract made on account of natural love and affection, suppose if a father transferred some property to his children, then there is a fiduciary relationship between the parent and the children, so there must be a love and affection arises between the parties. Then in such cases any contract, any agreement is said to be valid even though no consideration is from the other side. And similarly, any compensation paid for the past service rendered, say for example any voluntary act. So if someone finds any gold, any valuables on high seas, high road, so he will find out the owner and he will return that valuable thing to the owner. In such cases, the person who got that particular valuable thing can give something to the person voluntarily, but not necessary that he must pay some consideration. Then in case of creation of agency, agent is a person who acts for the principal. In such cases, that agent not necessary to get consideration because he will get remuneration, so no consideration is necessary. And lastly, that is a promise to pay time barred debt. Time barred debt means always in all the money cases, the case must be filed within 3 years or money is to be returned within 3 years. After 3 years, no one can claim money from the other party. In such cases, it is said that the party can, if the parties agreed to pay some amount of a time barred debt, it is valid. And according to section 10, competency of the party is very important. As per the section 10, it clearly says, when at the desire of the promisor, promisor and other person are competent to contract. So competency is very important. So what is a competency? If a person attains the age of majority, so what is the age of majority? Attainment of 18 years. So anyone who attained the age of 18 years can enter into a contract, and a person who is of sound mind can enter into a contract, or else a person of unsound mind or a minor are disqualifying from contract by any law. So any contract with a minor is void ab initio. So if you enter or if you give money to a minor, you cannot take back from the money from the minor, even if you file a suit, you will fail in that because no contract with a minor is valid. So you cannot enter into a contract with a minor, even no estoppel, no ratification against a minor. So even if the minor ratifies his act after attaining majority, then also the suit cannot be placed because any agreement with minor is void. Again, in some cases, so any minority during minority, even if after attaining majority, the minor cannot ratify or it cannot any act or any agreement or any contract enforced by the minor is, even if the contract is valid, he cannot accept it or no ratification. But somehow if anything done for the necessity of a minor, say for example some cost has been incurred for the purpose of education or the basic things such as food, clothing and shelter, if some has been served to the minor, that can be reimbursed if the property is there in the hands of the minor or else not. Then person of unsound mind is a person who is incapable of entering a contract because he is incapable of understanding between the right and the wrong. Suppose if a person of a lucid mind means sometimes the person's mind is stable. In such situation he can enter into a contract, but if he is fully unsound mind, no contract can be entered into. Similarly, contract with an alien enemy means a foreign enemy, contract cannot be made with a convict who has been punished and he is serving punishment in the jail, he cannot enter into a contract, nobody can enter into a contract with him. Then insolvents who declared as a bankrupt, who has no money, one can enter into a contract with him. Similarly, a foreign sovereign and the foreign ambassadors, they cannot make the contract valid. Then one more important thing of the contract is the free consent. Everyone knows when we want to enter into a contract, we have to enter the contract with our free will. No one can force us to enter into a contract. So in such cases, every contract must be with a free consent. Consent means free of mind. We are willingly to enter into a contract. So when two or more persons have said to consented and agree to do the same thing in the same sense was what we called as consensus ad item. Consensus ad item means agree to do a thing, same thing in the same sense. That means if the two or more parties, what the A says, B accepts the same for the same. In such cases, it is considered to be free consent. So when a consent is not said to be free, if it is caused by coercion, undue influence, fraud, misrepresentation or mistake. If any consent is obtained by putting a person in fear of any injury to the person himself or to the property of another, or any person to prejudice any person with an intention to make him enter into an agreement, that is called as coercion. Coercion means forcing the other person or threatening the other person to make him to enter into a contract. Say putting a pistol against a person and signed on a valuable document, that is nothing but a threatening. So in such cases, putting a person in coercion is not considered to be a valid contract, it is a voidable contract. So any agreement made by putting the person under coercion, the party who has been aggrieved can file a case to declare that agreement as void. But naturally, constitutional right of strike and statutory compulsion is not to be coercing. Strike is nothing but goes against the owner, but it is constitutionally provided, so it is cannot said to be a coercion. Next is undue influence. Undue influence means if the relation between the parties are subsist so that one of the parties is in a position to dominate the will of the other. That means if a parent and a child, If a parent can dominate on the will of the other, or a parent can force the child to do a particular act. Similarly, employee and employer, counselor and the client, doctor and the patient, they are all put some sort of pressure on their subordinates. In such cases, if the relationship between the parties are such that one of the parties are in a dominating position, using that dominating position, if one party taking an unfair advantage over the other, if the son is having much of money, if the parent putting a pressure to hand over or transfer all the money to the parent, because of the relationship, if the son transfers the money, it is nothing but an undue influence. Influence, all you know, it is undue. It's unlawful influence made by the party, that is called as undue influence. That in order to attract this undue influence, there must be relationship subsist between the parties. Such relationship must be real or apparent authority or fiduciary relationship, or there is a person suffering from a mental or bodily disorder. If a suppose person is dying or he is on the deathbed, so his relative made him to sign such a valuable document and thereby transfers all his property in his name, that is nothing but a mental disorder. That clearly mentions of undue influence. And next is fraud. Fraud, you always know. We always used to say that he is section 425. Who is 420? He is doing cheating. 420 we call it. So any fraud. Fraud means cheating a person. Cheating a person says that knowingly that anything is false, made known to the other that statement is true. Say for example, I am selling a house to you which is in a good condition, but actually that house is dilapidating or is about to collapse. In such cases, knowingly the true fact, if the person making a false statement, that is called as fraud. So fraud means and includes the suggestion as to a fact of that which is not true by anyone who does not believe it to be true. So the person making a statement knows that statement is not true, but he makes other to believe that statement is false, and the person believing on that statement acts upon and made an agreement with the other person, that is an agreement entered into is by fraud. But a mere expression of opinion is not fraud. Say for example, if someone says whether this house is good, his friend says, oh, it's okay. So it is just his opinion. So mere expression of opinion is not fraud. Similarly, mere silence is no fraud. But when there is a duty to speak, it is the duty of the person to make the true statement. In such cases, active concealment of fact, one having the knowledge or belief in that. Active concealment. So what is necessary to reveal? If the person does not reveal that fact, that is considered to be fraud. And then promise made without an intention to performing it. Taking a loan from a bank, knowing that he is insolvent, knowingly or intentionally not interest in repayment of the loan. In such cases, it is fraud. And any other act fitted to deceive, any such act, it is fitted to deceive. So by making any statement, made the other party enter into a contract on the false statement, is it nothing but a fraud. And then misrepresentation. Only difference between the fraud and the misrepresentation is, in fraud, the person making the statement knowing it to be false, but in case of misrepresentation, the person making a false statement believing it as true. The person making a statement does not know whether that right or wrong. Say for example, A wants to sell his horse to B, knowing that that horse is of sound mind. Even the seller does not know whether the horse is sound or not, but actually that horse becomes of unsound mind. In such cases, it is misrepresentation. If A knows the horse is of unsound mind, but believes B that it is of sound mind. In such case, it is fraud. So, in case of misrepresentation, always the person making the statement that he is making the true statement or believes himself that statement is true. So, any breach of duty which without an intention to deceive, it is a breach of duty. What he wants to make, if he does not make or does not perform his duty, but not with an intention to deceive the party, and then causing, however innocently, a party to an agreement to make a mistake as to a substance of a thing. That means by making that misrepresentation made the other party to accept that mistake by entering into a contract. That is misrepresentation, and always misrepresentation is a voidable contract. The parties can avoid the contract by declaring it as void, or if it has not made it declare as a void, it becomes void valid contract, or he can, instead of misrepresentation, he can affirm the contract. And lastly, mistake. So, mistake means there are two kinds of mistake. One is a mistake of fact and mistake of law. Mistake of law, no excuse, because every person knows the law of the land. So, no one can say that I was not knowing there is such a law. So, law is always binding at the person. So, but if it is a mistake of fact, then it can be a voidable contract. Say for example, if there are parties to an agreement is under a mistake as to a matter of fact which is essential to the agreement. As to the matter of fact means I am believing that I am having a cow or I am having any vehicle which is in a proper condition. So, and make the other party to enter or to buy that bike or to buy that horse. But the horse is dead before entering into the agreement or after entering an agreement. In such cases, both the parties under a mistake as to the matter of fact which is essential to the agreement. In such cases, it can be a voidable contract. Means when there is no consensus ad item between, if there is no meeting of minds, if both the parties have not consented on the same thing in the same sense, it is consensus ad item, that contract becomes void. Say for example, A wants to sell his car. A is having two colors of car, one is white and one is red. So, A is selling a white car, B accepts that he is taking a red car. That means if both the parties are under a mistake as to the subject matter of the thing which is essential to the agreement, in such cases that contract becomes void. Then it must be always mistake as to the fact, not of law. Then how a mistake can be made possible? It's a mistake as to title. If the person, title means ownership. If the person is not possessing any ownership, he cannot pass a good title to the other party. And mistake as to promise. Mistake as to promise, that means has not accepted or he was not knowing at the time of making the contract. And mistake as to identity of the parties. If the parties are under a mistake, there are so many cases on this. So, if the person he is the person with himself, he is entering the contract, but actually he is not. In such a cases, the mistake as to identity of the contracts. These are all the contracts, that's any contract made under a mistake is void. But however, if any contract made under a misrepresentation or fraud, they are all voidable contracts.